You're welcome to my channel. In this video we are going to be talking about the second officers of the company, and these are the board of directors in management of a company. The board of directors largely exercise the general policy control of the company, with the detailed management of the company being left to the managing director, and this is done by the board of directors delegating its functions to the single managing director. There is no definition of a director in the Companies Act or by case law, but nevertheless, Section 2 of the Companies Act states that a director includes any person occupying the position of a director by whatever name called. And according to Section 185 of the Companies Act, a public company must have at least 2 directors, and a private company must have at least 1 director. Let's look at the directors in a single-member company. A single-member company is a company incorporated under the Act with 1 person, whether natural or corporate. And an example of a single-member office is the Kabaka's office and the Bishop's office. A single-member company shall have 2 directors who shall nominate 2 individuals. And the first one is to become the nominee director in case of death of a single member, and the second one is to become the alternate nominee director in case of the non-availability of the nominee director, and this is according to Section 186 of the Companies Act. Let's look at the duties of a nominee director. Firstly is to manage the company affairs in case of death of a single member until the transfer of the shares. Then secondly is to inform the registrar of the death and provide particulars of the heirs. Thirdly is to transfer the shares to the legal heirs of the single member. And then lastly is to call the general meeting of the members and elect the directors. Let's now look at the qualifications of directors. The appointment and qualification of directors is generally governed by the company's Articles of Association. And below are the qualifications of directors. First, he should have consented to act as a director, and this is according to Section 192 of the Companies Act. It requires that before a person is appointed as a director of the company with share capital, he must have signed and delivered for registration his consent to act as a director, and he must have signed the memorandum of association for his qualification share. So someone should have agreed to act as a director and signed the memorandum of association. So that's the first qualification of a director. Then secondly, he must have been aged above 18 years. And this is according to Section 196 of the Companies Act. For a person to be appointed as a director, he must have obtained the minimum age of 18 years. And thirdly, he should not be undischarged bankrupt, and this is according to Section 200 of the Companies Act. It disqualifies an undischarged bankrupt person from becoming a director, or else a fine not exceeding 1,020 currency points or imprisonment for 2 years, or both, will accrue to the director. So someone should not have been discharged bankrupt, in order for them to become a director. Another qualification for a director is a person should not be convicted of any offense connected to promotion or formation of a company and breach of any duty to a company in which he or she was a director, and this is according to Section 201 of the Companies Act. And the last qualification is the share qualification, and this is according to Section 193 of the Companies Act. Where a share qualification is a requirement for one to become a director, the shares should be taken up within 2 months from the date of appointment, otherwise the director must vacate the office. Let's look at the remuneration of directors or payment of directors. A director has no automatic right to remuneration or payment. and this was seen in the case of George Newman and Company in 1895, Chancery Division 674. Court held that directors have no right to be paid for their services and cannot pay themselves. Let's now look at the conduct of the Board of Directors meeting. The rule is that the directors must act collectively, and any director who is prevented from carrying out his duties can seek an injunction from court to restrain his co-directors. And this was seen in the case of Barrow versus Potter in 1914, Chancery Division 895. Court held that these were not meetings because the members did not act collectively. Lastly, let's look at the conflicts between directors and shareholders. Where the company adopts Table A, Article 80 of the Table A stipulates that the Board of Directors is the supreme organ in the management of the company, though the shareholders are the real owners of the company. Therefore, shareholders cannot interfere in management of the company unless they are specifically empowered by the articles on the issue at hand. And that was an introduction to the Board of Directors. Thanks for watching. Don't forget to subscribe, like, comment, share with your friends, and watch my next video. We shall be talking about the duties of the officers of the company.